Hello guys, my name is Amaan Ahmad. I'm a legal intern at LEXIS and Company, and I'm pursuing 3 years law for Faculty of Law Delhi University in my second year. So the topic of today's video is how can a person call under the code of criminal procedure 1973. So how can a person be called to a court, or how the summons can be given? So there are many methods. So a well-settled principle of common law incorporated in criminal procedure 1973 is that the trial ought to be conducted in a presence of the accused person. So the accused person give him a fair chance to understand the nature of the prosecution case. So CRPC expressly provides that all the evidence in a trial shall be taken in the accused presence, and the accused has to seek the leave of the court to not attend a trial against him. So in some of these cases also the trial court may itself direct the accused to not appear before the court, and in other cases the trial court may direct the personal attendance of the accused in the court. So the Supreme Court in Bhaskar Industries versus Bhiwani Denim and Apparel Limited observed that an accused presence is mandatory to trial to enable the court to proceed with the trial. So the Supreme Court also held that the exemption from appearance under Section 317 CRPC shall only be given if it is in the interest of justice, and the accused gives an undertaking that yes, she will not dispute their identity during the trial, and the accused counsel has no objection regarding this. So first and foremost, there are four methods regarding attendance of a person under CRPC. So first is the issuing of summons, then there is issuing warrant for arrest, then there is a proclamation, attachment or selling of the property, then the last one is executing bond for attendance in the court under section 88, where the person against the whom summons or warrant were to be issued were present in the court. So there are three essentials also under section 204 of CRPC before any summons or warrant can be issued against any person, except under section 87 CRPC. So a list, these three essentials are: a list of prosecution witness has to be filed by the prosecution. Secondly, if the proceedings are instituted upon a written complaint, then the summons or warrant must be accompanied by it. So, and the last one is the process fee or any other fees that is prescribed in the law shall be paid. So first, if we talk about the concept of summon, so the summon is given in section 2 subclause X of the CRPC. It defines a warrant case. So in case in relation to any offense punishable with that life imprisonment or imprisoned for more than 10 years, while section 2 subclause W defines a summon case as a case other than a warrant case. So there is no precise definition given, but another section 2 subclause W, it defines only the summon cases as a case other than a warrant case. So summons may be defined as a written order of the court requiring the attendance of the person so summoned to the court. So summons are issued ordinarily in the summons case, and in the warrant cases at the court's discretion only. So they may be served through a police officer, a court officer, or any other public servant who the court directs. So if the person is someone cannot be found, the summon may be served to an adult male member of the family residing with the person to whom the summon is giving. So the Supreme Court also in Bhushan Kumar versus State held that there is no requirement of writing a reasoned order while summoning a person, but the magistrate ought to have applied his mind to the materials placed before him. Next, the summon is concluded. Now, if we talk about warrant, a warrant is an order by the magistrate to arrest a person, including a witness, and bring him before the court. So it is issued ordinarily in all the warrant cases, and even in summon cases also, if deemed necessary by the court. So it is on court's discretion. A warrant may also be issued in case of a breach of bond under section 88 CRPC, which was executed for the appearance of a person who was present in the court when the bond was executed. So a warrant of arrest is directed to a police officer or police officers in charge for execution, and it may be executed anywhere in India. So the person executing the warrant has to show that it is to the arrested person if demanded, and so state the reason also for his arrest. So it is within the discretion of magistrate to make the arrest warrant either bailable or non-bailable. So in Raghuvansh Bhasin versus State of Maharashtra, also the Supreme Court issued very detailed direction to the subordinate court and police with respect to the issuance of a non-bailable warrants. Then the next third one is the proclamation, attachment, and the selling of the property. So if a person is absconding even after the issuance of an arrest warrant, the magistrate may order proclamation and attachment of the property of the accused as per section 82 and 83 of CRPC. So the court also shall require the person against whom proclamation is published to appear at the specified time and the place within 30 days of such publication. So if a person does not appear at the specific time at the court has given, the court in cases of offense is specified under 82 subclause 4 of CRPC shall declare a person a proclaimed offender and seize his assets. So these are some of the movable property also shall be attached by Caesar. Caesar appointing a receiver, yeah, prohibiting delivery of attached property to a proclaimed person or someone on their behalf, like immovable property shall also be attached by taking possession, appointing a receiver, prohibiting payment of rent on delivery of the attached property to the proclaimed person or anyone on his behalf. So then there are offences also under the Indian Penal Code. One such as section 172 of Indian Penal Code, which makes punishable with a simple imprisonment up to 1 month and fine up to 500 for a person who absconds or avoids summons or notice deliberately. So that there is a section 173 of IPC, 174 of IPC, which deals with person not letting the someone to deliver to himself. Then there is section 183 IPC and section 184 IPC. So these are some of the punishable offences under Indian Penal Code that are that describes the punishment for avoiding the summons of warrant, and if the court is issuing it, you have to appear before the court. So thank you. I want to conclude my video. Please remember, this video does not violate any guidelines of Bar Council of India and does not solicit or promote any of their achievement, and is all purpose educational. And please subscribe to the channel if you haven't already to see more of this content in future, and I'll be coming up with the next video very soon. And please do provide a feedback to this video. Thank you.